Thank you, Karen. Yes, tonight is necessarily a bit more technical. It's not very technical. But even though I'll be providing more background detail, it's important you do stop and question me whenever you want to. Let me just see this, make sure this works. Oh, yes. Okay. So first thing I'll do is start by explaining the aims of tonight's meeting. The first thing is I've got a brief recap of the first session, and I also need a clarification, and I need to put something right which I said wrong, incorrectly. The second aim is for us to understand the stages needed to be completed in developing the legislation. And then thirdly, I'd like us to explore the sorts of provisions likely to be in our legislation, because really virtually nothing has been decided, so I've got to be really careful about that. And I'd like to look at some of the detail of things that have been contentious and previously have held things up. And lastly, I'm hoping that as we sort of go along, that you'll gain an understanding of the right that disabled people have to be actively involved and closely consulted about the legislation, and indeed the impact our exercising of that right has had. So, clarifications and corrections. There were a couple of points made in the first session we facilitated a couple of weeks ago, which I need to revisit. When we repeated the first session last Friday, by that time I'd corrected those things, so some of you are going to say, what's he talking about? He said that last time, but you know. So the first thing I need to correct is something about the legal status of conventions and a citizen's ability to challenge governments and domestic courts. Guernsey's human rights law does give effect to the European Convention on Human Rights, I was correct about that, and appeals under that law, when complaints are made against the government, can go all the way to the European Court of Human Rights. However, international and regional agreements dealing with the social, economic and cultural rights, you know, those, anybody give me a social, economic or cultural right? Somebody give me one. Right to have an education, right to employment, right, that sort of thing. So those sort of things, normally those agreements allow governments to progressively realise those rights. And because of this, those rights are not often given legal effect by domestic legislation. Instead of being able to challenge violations in an international or regional court, citizens and groups of citizens sometimes have an opportunity to complain to the UN. There is something called the optional protocol to the Convention on the Rights of Persons with Disabilities, which actually the UK has signed up to. That may be extended to us, but of course we don't know yet. But if it is, if it does get extended to us, that will give citizens and groups the right to lodge complaints with the committee of the Convention. The committee is only able to make recommendations, but these recommendations do have a powerful effect in that the country's international reputation could be harmed if that country was seen not to be complying with a UN committee recommendation. Is that clear? Okay. Secondly, there was some confusion about the example we used within Beryl's bad day. I don't know why I'm smiling whenever I think about Beryl's bad day. She had an awful day. Anyway, it was the thing about switches and sockets in her flat. To be clear, I was trying to make the point that although the Convention says that any disadvantage experienced because of disability is possibly discriminatory, the answer to many issues is most definitely not always discrimination legislation. With respect to the example about the sockets and the switches, in this particular case, the answer there is universal design and the building regulations. It's about setting standards so that people don't suffer that sort of inconvenience. So I hope that corrects and clarifies those 2 points. What I'd like to do now is a quick recap on the tools, because this is what the first session was all about. What are the tools that are available to prevent discrimination? The very first one, an obvious one, is the Convention on the Rights of Persons with Disabilities. In my view, that is the Worksop manual, the Swiss Army knife of tools to prevent discrimination, if you like. And the answer to everything is in that manual, just about. We said policy, but what was wrong with policy? Well, the good thing about policy is it sets a direction of travel, doesn't it? But we decided as a group that it wasn't particularly good at getting things done. You needed other things for that. There was very little impetus, and we gave several examples of government policy towards disabled islanders being ignored. Much more impetus in legislation, and particularly legislation works in two main ways, doesn't it? Prohibit discrimination, so that is to stop people doing things, so that's to change their behaviour. And the other thing that it might do is promote and protect rights to change people's attitudes, which then might change their behaviour. And lastly, we've already talked about it, we can use it to produce regulations. The big one, awareness raising. The government has a responsibility to raise awareness in all levels of society, we said, and we were particularly interested that saying that that awareness raising should start in our schools. We had another tool, hopefully we'll have the Equality and Rights Organisation. The three main things that equality and rights organisations do: promote, protect and monitor rights. We think if we get it right, our ERO, if we get one, will spend 80% of its time promoting those rights. The media and campaigns. Do you remember, anybody remember what we said the government's duty there was towards the media? It's to promote, what the government has a responsibility to do is to try and to encourage the media to portray disabled people in the way that the convention wants disabled people to be portrayed. And that is, the purpose of the convention is to promote, protect and ensure the full and equal enjoyment of all human rights and fundamental freedoms by all persons with disabilities, and to promote respect for their inherent dignity. The convention is unusual. It mentions dignity more times than any other international agreement. 44 times in that one document it mentions the dignity of disabled people. That's how important dignity is seen. So with that, does anybody remember some of the labels that Beryl thought that she might be suffering from? Object of pity, yeah. What else? What other labels? Hero, yes, absolutely. Yeah.
Charity.
Yeah. And the horrible one with the Daily Mail, do you remember what they were saying? Scrounger, absolutely. Well, there's a few more here that our disability cartoonist Crippen has perhaps offered. Right. Oh, and this next slide wasn't seen by the people who were in the very first session. And I've included this because this is a good example of a government policy that led to a campaign which, first of all, back in 1971, was about trying to get people to change their attitudes and behaviour. And a lot of people did change their behaviour and did wear their seatbelt, but a lot of people didn't until it became law. So this reminds us that we've got to use all those tools in our toolkit sometimes to actually achieve something. And this is quite a good example of it. The last couple of things, the government can use the assistance of NGOs, as long as they don't abuse us, to spread the word and to help prevent discrimination. So organisations like the GDA, Liberate and Get. The other thing that we recognised, that one of the work streams of the strategy was the audit of states' responsibilities, and that definitely will help prevent some discrimination, because I would suggest it's probably, I don't know how many, do you think hundreds of things to do that need to be changed? Thousands, probably thousands. A lot of them are small things that need to be changed. And the last tool, does anybody remember Eleanor Roosevelt saying, citizens all have a responsibility to promote the respect for other people's rights. So we have a responsibility too. Right. Let's look at going to the legislation now, and let's look at the decisions that have been made so far. And there have been three. The first one was to decide to have it in the first place. So the states passed a resolution to develop legislation to prevent discrimination, disability discrimination, and to provide equality of opportunity, very much in line with the two-pronged approach that we talked about before, but for a sort of complementing legal approach to change attitude and behaviour. Also in 2013, the states resolved to comply with the UN Convention on the Rights of Persons with Disability. And then last month, the Committee for Employment and Social Security made a decision that our future legislation should be based on the legislation of Australia and Ireland. This will be tailored to the Guernsey context. There were several factors in making this selection, but chief amongst those were how closely the legislation already complied with the UN Convention and how well it would fit the Guernsey context. Before I move on, has anybody got any questions on any of that, about the choice of Australian or Ireland's legislation? Anything at all? Great.
Sorry, Rob.
Yes.
Was it a very easy decision, or was it a marginal decision? And if it was a marginal decision, what was the second choice?
Actually, I don't know the answers to those. Probably, I don't want to put that on you, Ellen, but I mean, do you feel able to answer that?
I can try.
Go on then.
I don't think it was a marginal decision. That's what our consultants recommended, and they looked at all 5 countries. They were very quick to dismiss the UK. They felt that was appalling, I think was the word.
Oh, you've stolen my thunder now. I've got that in here.
So UK was quickly out. Canada, there was much appeal to the Canadian approach, which was very elegant, simple, relatively brief, clear legislation. So in that sense, it was great. But the feeling was that we don't have the human rights culture that the Canadians have. We don't have a constitution which protects people from discrimination. So in Canada, there's this sort of constitutional and legal protection, and we don't have a constitution. So, and in Canada, a lot of the guidance around the legislation is developed by judges who are very aware of human rights. And again, we don't have that sort of base of knowledge in Guernsey. So whilst they like Canada, they didn't think it would transpose well to Guernsey.
Yeah.
And New Zealand, the feeling was that the New Zealand legislation was highly complex. It's a long piece of legislation that cross-references into all sorts of other pieces of legislation, so you can't just read it and know what is and isn't allowed. And also it didn't explicitly talk about reasonable accommodation, which is a kind of key element that we will have in our legislation. So in that sense, so that sort of left Ireland and Australia, but that sounds like we've picked the best
Hong
of a
Kong
bad
was
bunch.
also rejected, but that's because they thought it was a bit clunky.
Yeah.
Well, there's one or two good things about the Hong Kong, but I'd agree it is quite clunky.
Yeah, so they felt that Australia and Ireland best met the various criteria that were agreed by the committee in an earlier session.
So we are going down a different route to our sister island, Jersey?
Yes.
We are. And you're going to learn about that in a minute.
Thank God. We're doing it properly.
You'll learn about that in a minute. Okay.
And
Thank you, Ellen, very much.
About Australia based and Ireland based on Australia, did you say?
I didn't mention that, but yes, again, if people think it's a bit strange to use 2 different countries' legislation to base our legislation on, it might help you to understand that the Irish legislation used Australia is very much informed by the Australian legislation. Right. So if you read them, there's, the definition of disability is almost identical, isn't it, Rob? And there's you can see that there's a lot of similarity in it. So
I missed the second part of that, but I don't think we had considered at all, did we, the American states, especially the deep south ones, because perhaps they're not so up on the...
The Americans have one main piece of legislation, the Americans with Disabilities Act 1990, and their definition of disability is almost as awful as the UK one, so we're not going to go there. And you'll see why. I've got some information on that in a minute. Right. What I'd like to do now is to look at the steps, some of the stages that we have yet to go through. The first one is that ESS has got to decide the scope in terms of the grounds to be protected, whether it's going to be just disability or others, or more multiple. And I'm going to talk a bit more about that later, so I'll carry on to point number 2. After the initial review of the Australian and Irish legislation, then the committee will have to identify resources needed for the tailoring stage. And ESS then has to obtain those resources by tender or whatever, or maybe not. I'm not sure whether it means they'll have to go out to tender, or whether ESS may be able to extend the contract they have with the experts from Ireland. I think we're all pretty happy with the work they were doing, and I think they are currently exploring that. Got a nod there, good. On the third point, once we've done that, we have to develop the policy proposals to tailor the legislation. Now, this is the technical part, and the part we should be particularly concerned with getting right. It is also the part that disabled people and organisations in other jurisdictions have often failed to get to grips with and be actively involved with. I should be clear, I'm not meaning to be critical of disabled people or their organisations. It's just that the detail of the law is often left to lawyers and businessmen to sort out. We probably shouldn't be surprised then if the law doesn't necessarily work in the way the people who are meant to be protected by it might have expected. There is a temptation just to follow what someone else, close to home sometimes, has done rather than look around the world to see what might be better. That is why the Isle of Man and Jersey, that's what the Isle of Man and Jersey have done, for example. Yes, both jurisdictions may have beaten us in terms of getting legislation on the books, but it's not the best legislation they could have achieved. Their legislation is likely only to be as effective and accessible as the UK legislation it is based on, and which experts have recently described, as you've already heard, as appalling. And it appears likely that neither piece of legislation will comply with the UN Convention. Often, disability organisations simply don't have the expertise or the time needed to provide this input, and we certainly do not have the resources to employ experts to argue on our behalf. That is actually why the GDA exists, really. Also, I'm not saying we're experts, we're better than nothing. Also, sometimes governments don't fully recognise the right of disabled people to be involved in the process. That right is clearly set out in Article 4 of the Convention. The good thing is that not only have disabled people in Guernsey been involved in the process since the start, but there is now a welcome, if somewhat overdue, focus on the guidance given by the UN Convention. And also, the further involvement of the independent experts will help give some balance, which was missing from the original disability legislation group, me and a bunch of lawyers, and should help speed things up. Before moving on to point 4, it's worth noting that ESS hope to have the business plan for the Equality and Rights Organisation completed ahead of the next stage, which the next stage is public consultation. When the draft proposals are put out for consultation, I'm hoping that ESS, heads up, will use the consultation as part of the education process. There are some important principles stipulated by the UN Convention which should really not be offered up for debate. The consultation process could be an opportunity to set out certain things which aren't up for discussion, as well as to gauge feelings on matters which are, such as perhaps the timings and the extent of liabilities and perhaps even the remedies to be available. Once the responses from the consultation have been gathered, the policy letter can then be drafted. Again, the GDA will be involved. The finalised policy letter will then be submitted to the GREF, which in turn will include it in a BA to go to a states meeting where it will be debated and agreed or amended.
Not amongst the states.
Sorry?
Surely not amongst the states.
Well, sorry, it's got to go there, I'm afraid. You'll see number 8 talks about the need to get policy and resources to prioritise the drafting. One issue here is that there is a danger of Brexit slowing things down. However, I understand that ESS are looking for ways of requesting P&R to dedicate resources early so that we're actually going to be hopefully drafting as the policies are developed. That's the idea, I think. Another nod?
That's what we like.
That's what we'd like to do.
Yeah, we're exploring that with the law firms at the moment.
Right,
Yeah.
okay.
It's not a definite, yeah.
Okay, simultaneous to the legislation drafting being finalised, we hope we can get on with setting up the enforcement mechanisms, developing the training and guidance, and even delivering that training. What isn't clear yet is who will be responsible for developing the guidance, whether ESS does this work or whether the Equality and Rights Organisation might be available by then to assist. I think it might be a bit early, but we'll see. Whoever is identified, the GDA will certainly have input. Once drafted, the legislation will return to the states for final approval. And once approved, the legislation will finally go live on an agreed date, which will be after sufficient training has been completed. The point of showing you all this is to I don't want to lower expectations, but we've got to be realistic about how long this is going to take. So there are many stages we have to go through. ESS, as you'll notice, has not published any timings by the side of this, which I think is probably reasonable. It's impossible to say at the moment. Other than the president of ESS saying she hopes to have the policy letter drafted in this political term. I think that's correct? Yeah. Another nod. God, good. Any questions on any of the process? John, sorry. Sorry, could you just wait for the microphone? One moment. John Gollop has got a question or a statement.
Predictably, some members of the audience are a bit sceptical about the state's political ability to cohere and deliver. But as I've said to Rob and other members the last few weeks, I would say one of the biggest challenges in Guernsey isn't just the states as politicians, it's prominent lawyers, actually. Lawyers who work in both the public and the private sector. I think if there's anybody who's going to read and contribute to the legislation, it will be people from the legal profession. And there's been a bit of a history in Guernsey, it's fair to say, of many lawyers not particularly welcoming wide-ranging rights that could ensure reasonable adjustment from corporates or firms or businesses. So I think it's very much important for the GDA and members and groups to very much acquaint themselves, as Rob already does, of all of the arguments and ensure that if you do get pushback from the legal profession on a political or legal level, that you're ready for it. Because it's not enough for members to passively just think this is all going to happen.
No, I agree, and members ought to be appraised of it, and that's actually why we're holding the session today. So thank you, John. Sorry, Karen.
I'm just going to mention that's why Chamber sits on the legislation group. Happens in a second, just so that people know that they are being sort of consulted as we go. But obviously, like John says, a lot more will come out of that. So I just wanted people to know that, as I say, Chamber of Commerce is on that.
Yes.
On the legislation, will it need to go to Privy Council?
Can I deal with that in a moment?
Because
Can I deal with that in a moment?
if it has to go to Privy Council, how are they going to respond to the fact that you've decided not to follow UK legislation?
Okay. Can I deal with that in a moment?
You can.
Because I'm going to be talking about the Privy Council, so we'll be doing it twice otherwise. Andre.
Can you expand a little bit on what you understand the training will be, and or what your aspirations is in relation to the training?
The training will be about the provisions of the legislation. It will be about things like what the duties of making reasonable adjustments are. That sort of thing. We'll develop the guidance and train that guidance. I think that's the way to explain. Okay. I will come back to that other point then. Right. In fact, I'll come to it right now. Sorry. Are we going to have a law and ordinance, and what's the difference? So who can tell me what the difference is between a law and an ordinance? It's almost been given away here, but... Okay, so laws developed in Guernsey have to be approved on behalf of Her Majesty the Queen by the Privy Council. However, laws agreed with the Privy Council can then be used by the states of Guernsey to develop secondary legislation. Because this secondary legislation will be developed following the requirements of the guiding law, then they don't need any further approval from the Privy Council. In general, we should be able to get ordinances passed and in force faster than laws. That's the point. I'm pretty certain we can say this is going to be an ordinance. The law that we have is the Prevention of Discrimination Enabling Provisions, Bailiwick of Guernsey Law 2004. It is a concise and clever piece of legislation which gives the states of Guernsey broad and comprehensive powers to develop further legislation to tackle discrimination. I don't intend to go through all these powers tonight, but in a nutshell, Guernsey can protect whatever ground or grounds it chooses from discrimination, using any means it sees fit. It is very likely that our legislation will be an ordinance. Good, yeah, I agree, good, yeah. It would be a nightmare, wouldn't it, if we had to go for a law. So I'd like to move on now to look at how our legislation might work and what might be included. Another big list. I'm sorry about this big list, but I'm not going to go through all these things. This is a list really of what might be included in your average common or garden bit of discrimination legislation. We haven't got time to cover everything on this, so I offer the list to show the breadth of policy and planning which must be covered by the lawmakers and to prompt questions and thoughts from you. I only intend to cover the first 3 items on the list: scope, definitions and prohibited acts. This is because these have been the issues which have previously held us up and been contentious. However, if there is time and you're not falling asleep by then, we might also discuss awards. We'll see. So, grounds to be protected. We touched on this issue in the first session. We did, but we didn't discuss this when we repeated the session on Friday. So it would actually be interesting to hear people's views about the pros and cons of whether our legislation should just cover disability. The options basically are just disability, or many grounds from the start, or many grounds in a phased introduction. I put a little note there to say that the Convention requires laws must allow complaints on multiple grounds and must take account of something called intersectional discrimination. Basically, multiple grounds means it might be somebody who's taking a case because they're disabled and because they're a woman. And intersectional means that perhaps a disabled woman might experience a form of discrimination that neither a woman nor a disabled man might experience. So if you have it in your mind that the Convention is saying that our law ought to be able to allow complaints on multiple grounds, it is obviously a bit difficult if our legislation doesn't cover multiple grounds, although it's not impossible. It would not be great if it did. There are examples around the world. There was a case I can think of called Vrend versus Alberta, where Alberta was taken to court because a gay couple had been discriminated against, and Alberta said, we don't cover your sexual preference in our legislation. But it was in the Constitution, and they took it to the federal court and won. So there are sort of precedents, but it would be very messy, and it's the wrong way to develop legislation. So some views about whether our law should have multiple grounds, like sex, age, religion, right from now, or in phase stages, or disability first, or anybody got any views? Yeah. Sorry, could you repeat that again, Brett?
I do think they should just concentrate first on where they already know discrimination is happening. Like with no access and mobility for those who are immobile, and anything else you wanna mention that is happening that we're aware of. Sure.
Okay, thank you for that.
Can I comment on that briefly? No? Okay.
Yes, you can. Yes.
It was just Kate was going to be here from Citizens Advice
Yes.
Bureau, and it came up yesterday in the Equality Working Group. So if somebody's not aware, the Equality Working Group is a representation of all areas, so Liberate, Age Concern, Youth Commission, all. And it's exceptionally difficult in Guernsey to actually get data around where discrimination is taking place, because there's so little in the way of employment law and so little already around discrimination. A lot of people just don't take it, or they don't ring for advice, and there's nowhere, for example, we don't have an equality rights organisation at the moment where this would be recorded. So a lot of what happens locally is on hearsay and through the groups themselves. So for example, Liberate around sexual preferences and gender is actually quite a difficult one to get hold of. So yeah, just wanted to, it's quite a difficult area in Guernsey to get really good data.
It is. From a human rights point of view, it is sort of discriminatory. It's discriminatory to do it any other way than to protect everybody in all grounds from the start. Sorry, yes, Rob.
I'm just going to express a personal view. There's all sorts of reasons I support Canadian models, of which the first is that I'm Canadian. But one of the most amazing things about the Canadian law, I think, is its simplicity. And I think bringing things in piecemeal is inevitably more complicated in the long term. You can make a more simple ordinance based across all grounds, marking out what is unique about disability or what's unique about other characteristics. And so I would be very keen to promote bringing in the whole thing at once for the sake of actually having a law we can use. One of the things we might say about Jersey or about the UK is their law is blooming complicated.
It is indeed. Yeah,
Can I just say, although I work in adult disability, I just think that it takes so long to get ordinances and laws pushed through, that, and I really feel passionately as well about mental health and just discrimination in regards to mental health in employment, and I think that it would be great if that could be encompassed as well as sex discrimination, disability and all the other important areas of discrimination.
Mental health will be included within the disability provisions, absolutely. Yes.
Yeah.
Any other?
Is this chicken and egg? Is that what this is, chicken and egg? I mean, what would be the best way forward first? Would it just be an equality law and then discrimination, or is it the same thing? I mean, what's Guernsey's problem? What's stopping this equality not being equal?
So a good equality law includes provisions to prohibit discrimination as well as promote equality. And that's what I hope we'll end up with. I hope we'll end up with both those things. I think there's a question over... Yes, sorry.
As I understand it, Guernsey is woefully behind on a lot of social issues. So when the government does capitulate on disability, then we should push them for everything we can get. So that, especially considering that means we wouldn't have to worry about it later. But because it's the right thing to do, and if they're capitulating on one thing, maybe they'll capitulate on the next.
Yes, I think there's some other things here, aren't there, about... it might actually be helpful for disabled people too, because we were always concerned that we don't want to appear to be getting something that somebody else isn't getting. Or that people suddenly think that disabled people have more rights than everybody else. So by bringing it in all at once, there is an argument that it makes everybody the same. And I love that, and that's what I loved about the Canadian model, that it doesn't treat us differently again. And we actually would like the legislation, I personally would like to take the same approach that Canada does, which is called a unitary approach, where all the provisions that rationally can be the same will be the same, rather than having all this raft of different provisions. Things like reasonable accommodation should apply to all the characteristics, as they do in Canada and elsewhere. And why not?
Can I ask a question, Rob?
Yes. Sorry, we'll just wait for the microphone. You need your running shoes, Karen.
So currently the agreement from the disability strategy is to create a disability legislation.
Yes.
So if it was many grounds, would that mean having to go back to, could that potentially create a...
It could do. I mean, we have to go back to, when it goes back to the states, it will go back as a policy letter. And if the policy letter says, we've identified that it would be much better to include all the grounds, it would then set out those reasons. And yes, the states could turn it upside down.
But if it was just a disability legislation?
Yes.
And the states still reject it? Is that option still open?
They could, yeah, they can do anything they like. As far as I know, they could, although they passed a resolution, as long as the disability is in there, I don't think they could turn around and say, no, now we've changed our mind and we're not having disability. But as long as disability is in there. Yep.
Right, yeah, because so in answer to your question then, the pragmatist in me feels that the third option, many grounds with a phased introduction, so you get the disability first. Again, because of the thing about trying to make one thing looking more important than another, or being needed more than another, when it's a right, when disabled people have the same rights as somebody does on the basis of their sexual preference to be protected.
it becomes a little bit difficult. I mean, if it was a very short period of time, possibly, and we have to understand really what's the reason for not bringing it all at once. It isn't going to be that complex, especially if it's a unitary approach. Andre. Sorry, microphone's coming.
I'm just a tad confused. What do you actually mean? Define what you mean by all at once.
Oh, so that from day one, a lot of grounds could be protected. So that on the day that the legislation goes live, it means that people will be protected against discrimination on the basis of, say, race, sex, age, disability.
Right, because
right.
you could be black, you could be black, gay and disabled, you could be black, choose your own gender and disabled, you could be whatever, yeah. Is that what you mean?
But yes, however, there could be some provisions which would take a while. Say, think about the accessibility provisions we might put in. The legislation might be enacted, 1st of January or whatever, but it might say that within a year, you've got to take note of the duties under the accessibility parts and change your practices or your physical features of a building, if that was the case, and you've got a period of time to do it.
But is that not why we, and I include myself in that statement, is that not why we were calling for the ERO, Equality Rights Organisation, to be up and running now, so that X, Y, or Z in this room, as a business premises owner, has somewhere to come now ahead of legislation?
Absolutely right.
I accept fully that it would be unreasonable in those terms to expect, as of midnight of the 1st of January, that every premises in Guernsey has to be fully accessible. That would be totally unreasonable, and I don't think any disabled person is looking for that. So I think it's really important that message actually gets out, through social media or whatever, that disabled people are not looking for everything to be perfect. There's no such thing as a perfect world, anyway.
No, that's it's really important, because we don't want people to be frightened about this legislation. We want people to welcome it, don't we? Yes. And that's another reason why we don't need the UK legislation, because it's hardly welcoming. Sorry, any more?
I'll be quick. Back in the day when the initial disability and inclusion, it was always border, went to the States in 2013, perhaps some issues, for example, equality of marriage wasn't such an issue at that point. Things evolve. And what was interesting at the time, I think, in the early days of the GDA, there was a feeling from some members that the focus had to be on disability. I think, in reality, not representing any committee or association, I support the broader approach. I think you've seen, although an imperfect law in Jersey along those lines, and I think it makes sense for equality to be the focus and for the equal commission to get going and so on, equality and rights. There are risks, though. The risk, as Andy and others have suggested, is there's a possibility, for example, of a general election in Guernsey that would significantly change the composition of the members. There's a risk that the resources for some reason aren't delivered, or there's delays with the legislation, and there's risks of some members of the public losing interest, and all of those concerns. And so the more you do, the more you commit yourself to do, the higher the risk element. And so I think it's very much incumbent on people to work together at this time.
This highlights Andre's point to have an ERO set up.
I think there is a response. One of the things that Rob has emphasised so far is the importance of education and attitude changing. And that's not just amongst the public, it's also changing the attitude of the state's politicians. If there is an understanding that implementing the simplest and most effective legislation is bringing in all characteristics at once, then I think we're onto a winning game. And that's that little bit at the bottom of the toolbox that says that we have a responsibility. And any one of us that's on social media should be getting that message out there. That's what we want. And we don't just want it because we're representing disabled people or people with mental health issues or people of diverse sexualities or whatever. We want it because that is the simplest and most effective model for eliminating discrimination. And all of us can join together on saying what we want to do is eliminate discrimination.
Yeah.
You definitely feel the energy change when there's more of us. You know, it's not just
Absolutely.
the GDA, it's, you know, all of us.
The Equality Working Group must be a great thing to be on.
And the GDA, to its credit, represents every disability in the whole island.
Yeah.
Yeah, thank you. Now I'd like to discuss the fields of operation. Back in 2015, there was an attempt to model the Disability Discrimination Ordinance on Guernsey's existing sex discrimination ordinance, and to restrict it so that the disability ordinance, like the sex ordinance, only protected people in employment. In fact, a draft policy letter was developed on this basis, without consulting the GDA. This approach was explained as being expedient, and perhaps the only way to get some sort of legislation in place before the end of the political term, and which could be achieved with the limited resources available. The GDA executive rejected the policy letter and its approach entirely, for a number of reasons. Firstly, it was based on a legislative model from the 1970s, which is incompatible with disability and which is arguably discriminatory in the way its awards are calculated. But mostly we rejected it. By not protecting in education and when accessing goods and services, it does not comply with human rights principles. You will recall perhaps that human rights are interrelated and interdependent. We also knew that we needed the right legislation in place in order to have the UK extend the convention to us, and that the proposed legislation, the legislation they were proposing, could delay that for years. In that instance, the states also failed to respect our right, explained by Article 4 of the Convention, to be actively involved and consulted in the development of the legislation. That move wasted several months, and by the time the policy letter was rewritten, it was too late to make further progress in that political term, and before we knew it, we were at an election. To be clear, the Convention says that government should combat discrimination in all fields. And the UK requires that our legislation protects, as a minimum, in the fields of employment, access to goods and services, and education, before it will extend its ratification. Although, a bit like Mrs May explaining the Brexit negotiations, nothing is agreed until everything is agreed, I think we can be confident now that the policy letter, when it's drafted, will recommend that our legislation protects in all three fields. Had the GDA not stood up to that, we would now have legislation that only protected in employment and would not work well for all sorts of reasons. Our legislation will obviously state what sorts of actions are discriminatory and prohibited. So the first of those is direct and indirect discrimination. Can anyone explain or give examples of what direct and indirect discrimination are?
Direct discrimination is where you say, well, I'm not employing you because you're a wheelchair user.
Yeah.
We're not going to make it.
Yep.
Indirect discrimination can be by association. So it could be a carer or a family member.
Right, that's probably discrimination by association, but I'll come to that. You're quite correct about the direct, and I was going to give the example of an actual example here where some children with learning difficulties were not allowed to use a local gym because we don't have their sort here. Then indirect discrimination is when somebody applies a policy or a criteria or a provision which on the face of it is neutral to everybody, but actually has a greater effect on disabled people.
I've got a favourite one. There's many employers in Guernsey, private and public. Often you wouldn't these days see adverts being overtly sexist, perhaps, in the paper, but you will see adverts which will say, a driving licence is required. Now, by its very nature, people with certain kinds of disabilities are indirectly excluded, really, from applying.
If I take that example, if driving was necessary within the job, that would be something called a genuine occupational requirement. But if it wasn't, then you're quite right, it would be discriminating. I was going to give an example of locally, this is a real example, of a young person who applied for a job at one of the supermarkets, this was a few years ago, and was told that he had to write his application. The job that he applied for was to push the trolleys and collect the trolleys. There was no writing involved, and the lad had learning difficulties, and he didn't apply for the job because he couldn't write the application. Which leads me neatly on to the next thing, failure to accommodate need, or failure to make reasonable adjustments, which is the UK expression. Nobody else uses it in the world, so I want to stay with the UN conventions, failure to accommodate need, because that's what it's about. In that situation I gave you the example of, the young lad who couldn't fill out his application form, might have been a reasonable accommodation there? Yes, or indeed the manager who interviewed him in the first place might have just asked him the question. It's that simple. That reasonable accommodation would have cost nothing, but his failure to accommodate cost a person a job. So our legislation will definitely have a provision for failure to accommodate need. But it goes much wider than that. It's also about, in employment, the duty is towards an individual person. We have to be very clear about that. And our legislation is very likely to treat it differently to general accessibility, where there could be an anticipatory need for the general public, for instance. So the two things will be likely to be dealt with separately. Harassment. Anybody explain what harassment is? Yes? Yeah? Yeah, it's an action which is, yeah.
Persistent detrimental treatment.
It can be persistent, and some legislation asks for it to be persistent, but actually I think the Equality Act doesn't. It just says conduct, which is, I think their words are, that causes distress, persecutes, or intimidates. But generally, it's about a course of action that would intimidate somebody. Victimisation. Anyone know what that is? Absolutely right. Gold star. So just to repeat that, it's when somebody is singled out and disadvantaged because they were supporting somebody who was trying to protect their rights. So it might be somebody who'd complained about being treated badly. I mean, in obvious cases, say there's a case I can think of where a gentleman with learning difficulties was removed from a pub, and his friend said, "You can't do that," and he was then barred as well. So that's an example of victimisation. You'll note that the first four are required by the convention. You see the things with the little asterisks on. Why might victimisation not be required by the convention? Any idea? Actually, you're not going to get this, I better tell you. It is simply because under the convention, you don't have to have a disability to be able to claim discrimination on the basis of disability. You can claim discrimination on the basis of disability if you have an association with somebody with a disability. So I would suggest to you that victimisation you would automatically be an associate of that person, even if you've only known them for 2 minutes, and you would then claim direct discrimination, which is covered by the convention. That's my thinking. Okay. There are other prohibited acts, things like pre-employment questions. Why is it important that people aren't asked about their previous health record before they're offered a job? Anybody? It'll be used against them as an excuse for not giving them a job. Absolutely right. And in fact, there's been quite a lot of research done showing that people with disabilities, if they admit to having a disability, even at the application form stage, they are systematically discriminated against. There was somebody who actually did a study, very naughty, sent out something like 100, from memory, of 100 application forms, and the only difference, half of them, they said they had a disability, and the other half, they didn't mention any disability. And the difference in the getting to the interview stage was quite remarkable. Sorry.
Oh yeah, I have that a lot, obviously, in my line of work. Where you've got a lot of people who will want to put it in or feel that it's something that they should put in, and I always advise, and unless it's happens to be in there because it's in your hobbies, as I do blind football or something like that, you're focusing on your ability and your strengths for the job, not that. And I think people struggle with that sometimes, actually, but
it is illegal in many places in the world now. It is even illegal in the UK and America and Canada.
It's amazing the difference it does make. We've definitely had experience of that. If you say it too early on, people, I'm not interested.
Okay, thank you. And then discriminatory advertising and so on. Right. Next on our list, I would like to go now to another rejection from the GDA, medical models of disability. The definition of disability will have an effect on who is protected. This subject exercised the first disability legislation group for about a year, probably more than that. The issue back in 2014, when work started on the legislation, was that the lawyers in the room would not accept that the definition of disability should be based on a social model understanding, even though this is mentioned all the way through the strategy, and indeed it goes to the very core of the UN Convention, which the states had already agreed it will comply with. The lawyers wanted us to follow a UK model which defines disability in medical terms as a condition which has lasted or likely to last for 12 months. That condition must substantially restrict the person's ability to carry out daily activities. When some of the earlier disability legislation was developed, particularly in the UK and in America, the world in general was still looking at disability as a problem confined to the person, a medical issue rather than a human rights issue. Records of the UK parliamentary debate and of the debates in the US Senate when they were passing their disability discrimination legislation shows that representatives of both places were concerned that broad definitions of disability would open a floodgate of complaints. There were a number of members of both governments also suggesting that only the deserving or genuinely disabled should be protected from discrimination. Thinking back to our human rights session, how do the notions of only the deserving or genuinely disabled being protected fit with the human right model? What sort of human rights might they be forgetting about the qualities of human rights?
Dignity.
Yes, dignity, but do you know what is it called when you're born with them? Inherent. Great. So you're born with these rights. We're all born with these rights. We're born with these rights not to be discriminated against on the basis of disability. And the UN Convention even says you don't have to be disabled to experience disability discrimination. They are definitely not earned or deserved. Everybody has them. So can anybody see the effect of this sort of definition? So, well, it does. It means that how long someone has been impaired and whether or not someone's impairment affects personal functionality may have absolutely no connection with the discrimination a person has experienced. It means people have to prove how long they've had an impairment and the effect on personal functionality. People complaining on other grounds do not have to prove this eligibility. This means that all disabled people potentially face this additional burden of proof, which people seeking protection on other grounds do not have to overcome. I'm not aware of any jurisdiction which protects on grounds, for example, of sexual preference or religious belief, which requires proof that a person is gay, or indeed how long someone has held their religious views. This does not seem to be equality before the law, as required by the
You're
Convention.
being heckled by Gollop, he said it's not true.
What? Sorry, what?
I'm afraid to say, I believe the states of Guernsey, if you want your child to go to a particular denomination school, you have to prove that you have been in that religion for a very long period of time from birth.
Sorry, John, I'm talking about when challenged in a court of law.
Yes,
which is
they
different.
did go to a tribunal, but perhaps a court ruling on that for another day.
So what I'm saying then, though, that if you did go to the court of law, in the court of law here, if we protected religion, that particular person you were talking about wouldn't have to prove to the court how long they'd had that particular faith. That's the point. But these definitions can lead to an assault on the dignity of the person, as it can mean sharing very intimate details which have no relevance to the particular complaint. These qualified definitions can have the effect of inviting employers and service providers to decide whether someone is disabled enough to have to accommodate their needs, or not disabled enough to be in trouble if they decide to discriminate against them. The other issue is that there are many disabling conditions which are short-term, but the effects of discrimination which can be experienced may be substantial and long-lasting. Long-lasting discrimination in connection with a short-term impairment, anything less than 12 months, is not covered by UK law. Can anyone think of an example of a short-term impairment that might lead to a person being discriminated against? Just on that question, there are lots of mental health conditions which are short-term and solvable within a year, within 6 months sometimes. And none of those conditions would be covered under the UK law. Yeah. Under the original UK Disability Discrimination Act, almost a quarter of all complaints failed without the court or tribunal ever getting to the stage of considering the discrimination, simply because the complainant couldn't get past the first stage of proving they qualified as a disabled person. Actually, under the original Act, somebody with disability, somebody with MS was told they weren't a disabled person because on the day that they were discriminated against, they didn't have any symptoms of MS. Fact. In America, under the original Americans with Disability Act, 1990, 93% of complaints were unsuccessful. That act was described by Professor Ruth Kolker, writing in the Harvard Law Review, as a windfall for defendants. Thankfully, many other jurisdictions, in fact a majority of the 38 studied by the GDA, either do not define disability at all or define it in broad, unqualified terms. Going back to the concerns about the opening of floodgates, they have been proved to be completely unwarranted. There is evidence that in fact the opposite is true. The stigma still associated with disability stops some people who might have a legitimate complaint from actually complaining. Many people tend to hide their impairments simply because of the stigma and the prejudice. So you might see now why the GDA has fought so hard for our legislation to work in a different way to the UK. We have consistently argued that our legislation should be based on a social model and concentrate on first establishing whether there is a complaint of discrimination to answer, rather than first establishing whether there is a disability. It was particularly disappointing that the GDA suffered implied criticism in the recent scrutiny committee hearing into the delays in the strategy. When considering delays to the legislation, the committee seemed to be suggesting that the GDA might have been at fault for not compromising on the definition issue. But as you'll remember from our first workshop, rights are universal and they are inalienable. They cannot be compromised, limited, or negotiated. The notion that some people should be protected against disability discrimination but not others, and that some disabled people should accept not being equal before the law, especially the very law which is meant to be preventing discrimination, is, to me at least, difficult to grasp. So, what does the Convention have to say about defining disability? Well, actually, the Convention is careful not to define disability at all. Instead, in the preamble, it says, disability is an evolving concept, and disability results from the interaction between persons with impairments and attitudinal and environmental barriers that hinders their full and effective participation in society on an equal basis with others. This explanation clearly suggests that disability is not simply a personal characteristic like, say, age or gender or sexual preferences. Disability is a condition which can result from or involve both the person's impairment and the environment. Sometimes it's either one of those things. Fortunately, very recently, in fact, I think it was March, the Committee of the Convention on the Rights of Persons with Disabilities has published further useful guidance. The committee said, persons should not be burdened by proving they are disabled enough in order to benefit from the protection of the law. Anti-discrimination law that is disability inclusive seeks to outlaw and prevent a discriminatory act rather than target a defined protected group. In that regard, a broad impairment-related definition of disability is in line with the Convention. You may see that the UK definition and the burden it puts on people, together with its failure to focus on barrier removal and on preventing discriminatory acts, is not compliant with the UN Convention. Whilst I stress again, nothing is decided, I think it is highly likely now that the draft legislation will take note of the UN Committee's recent advice. I would say too that the definitions included in both the Australian and Irish legislation are broad and would require little amendment. And the good thing is there's plenty of evidence of those particular definitions being in use. Any queries or questions or comments on the definition of disability? I mean, we've done quite a lot already, but is there anything else? Any other questions? Yes? So just wait for the microphone, please.
It's for the cameras.
Yes. On the UK one, how does is it based on case law? Because it says long term, but it doesn't define what long term means.
No, there is guidance.
Right.
Sorry, I should have said
guidance behind
in the UK it's 12 months.
Right. The normal activities, does it actually define what constitutes? Under
the original 1995 Act, there were a lot of activities described as normal. And you're absolutely right. Thank you for leading me here. There were all sorts of arguments and litigation about what is normal and what does everyday mean, what does even substantial mean. And so they've had to make rulings on all these things which are completely bonkers. And in fact, the guidance in the UK now runs to 50 A4 pages. And it's I mean, if you can understand it, then great. 50 A4 pages. Contrast that with the Canadian advice from the Canadian Supreme Court, because Canada, in their federal legislation, doesn't give a definition of disability. But the Supreme Court about what disability is doesn't run to 50 A4 pages. It runs to 2 paragraphs. And it's so much easier for everybody to understand, and it's so much fairer. Thank you, Catherine. Great question. Any other questions on that? Yes, please, Brett. Yes, please.
All right. Yeah, for the purpose of the legislation that's you're aiming for, just clear something up for me about where, because if I put my state's cap on, you know, if I was a states member or someone in Social Security, you're always going to have to prove you're disabled or what disability you have to do certain claims. And for example, like when I lived in England, you get a form that's like a phone book you've got to fill out, and it's the same over here. And every single year, this is what winds me up over here specifically, is I get called into Social Security once a year to do this form again, and I tell them I'm still blind, and they're like, well, you've got to come in and do the form. And is this what you're getting at? Is the protection of... We don't need a definition of... How are we going to have people not prove they're disabled? Will there just be enlightening where they say, right, you're blind and it's a terminal condition, that's fine. Andre, you're in a wheelchair, that's terminal, that's fine. What's this section about?
Right. No, so this is not about benefits. This is about rights, not needs. And there has to be a different definition of disability or different rules when we're coming to service people's needs. So if there is a right to not be discriminated on the basis of disability, you don't have to prove you've got that disability. But if you're going for a benefit, then there is an argument that you must, of course, show that need. There must be some proof of that. But actually, on the point you were making about having to continually prove that you've got a permanent blindness, I would agree with you. If that's what's happening, then I would suggest it definitely needs looking at. And you could challenge systems, perhaps, under this legislation.
But the new legislation helps protect those people.
There's a possibility if you could show that you were discriminated. It's going to be a difficult one because you'd have to show that you were discriminated more than somebody who isn't blind. So it becomes very difficult to show this, to find a comparator. That would be a difficult one, and I'm afraid I'm not a lawyer, so I'm sorry, I don't think I can answer that.
Well, you cleared it up a little bit, cheers.
Sorry?
I was saying you cleared it up a little bit, but
Okay,
I was saying
thank
that's
you,
right,
thank
John
you.
sits
Good.
opposite him, so he could bring it up.
Great.
Yeah, okay.
Thank you. Right. Continuing on the same theme, a bit more information from the committee. The committee gives further advice which says that laws should include past, present, future and presumed disabilities, as well as persons associated with persons with disabilities, and that would include carers. The sort of definition of associates has yet to be decided, but in some legislation it's very broad indeed. It is literally anybody with an association with a disabled person. Any question on this advice here about past, present, future and presumed disabilities?
I'm just trying to work out how future would play.
Great question. Genetics. So if somebody finds out that you might have a genetic disposition, or if you had HIV, then the future disease, if I got this right, then the future disease would be AIDS, and somebody might make the assumption that if you had HIV, you might then get AIDS, and might possibly discriminate against you on that basis.
That's the same as employing a female. Could you get pregnant?
Yes, indeed.
It's very similar in terms of the legislation.
Yes, it is.
Or should be.
Yeah. Yeah.
Sorry,
Yeah.
would that be the same as if you had a gene, like a defective gene?
Yes.
Where you possibly could have cancer at
Yes.
other times in your life, and they say, well, you might be able to.
Yes, absolutely right. For them to discriminate against you because of that would be included in the law. You'd be able to take a case against them.
That's not in the that's over here. Is that in the UK?
Yeah, well, it is actually. There are a couple of famous cases, but only to the point where the direct discrimination of that associate it happened. Of that future. Sorry, I'm getting confused. No, it is included as a future. Yes, if you've got the possibility of a future disease, yeah, then it would be included. Yeah.
I guess if you have the diagnosis,
Pretty sure that's right.
Go into remission.
Well, that's interesting. Under the UK law, they've got exceptions, and they've also got the opposite. They've got conditions which are automatically included. The two that are automatically included are cancer and multiple sclerosis. What isn't included, for instance, are all the other chronic diseases like ME. That's not included automatically. Parkinson's not included, it's not in the list. I mean, it's a bonkers law, crazy. But it's got all sorts of exceptions as well. Yeah, for instance, if you've got seasonal rhinitis, anybody know what that is? Hay fever. Now, some people really get chronic hay fever. And if you're working in, as I understand it, if you're working in very bright conditions, it can really make it worse. I would have thought that somebody's got really chronic hay fever, to somebody say, would you mind, can we have a blind on the window? I wouldn't have thought that's too much difficulty, would you? But no, under the UK law, couldn't ask for that, because it's not covered. Sorry? No. Okay. Right. Are you all feeling really knackered now? Okay, sorry. So you don't want to talk about awards then?
Sorry, I've just asked.
Yes,
what
please.
was presumed?
Ah, so that's when somebody believes or thinks or suggests that you might have a certain condition when you don't actually have it.
You're depressed.
Yeah. Or even, and part of this came out in the UK law, or even you're gay, therefore you must have AIDS. I mean, really, that's why it's there, really. Great question, thank you. Any other questions? Yes, please.
Back to the future thing. If so, you pass your anti-discrimination law. Would that prevent a future government from passing a law which prohibits people with genetically inheritable conditions from reproducing? Because I assume that discrimination law applies to government services, the government itself as well. I was just wondering. I know how unlikely it sounds.
No, well, under existing legislation, actually, under our human rights law, you can't stop people from having a family. That's a basic human right. That's under the Human Rights Act, and you could already challenge that right up all the way up to the European Court. And we don't do sterilisation anymore. It was carried out still in America until the Andre, you probably know, the 70s.
It was the 70s.
Yeah, but we don't do that anymore.
Forced sterilisations, was it?
Forced sterilisation.
Jesus.
Great question.
Still lots of encouragement, though.
Sorry?
There's still encouragement in a lot of places.
Is there? I'm not sure whether a law would. Well, the law would actually would encouragement to discriminate. That might be. It might be in the law. Don't know. Possibly. So I'm quite happy to leave it here. But if anybody does want to talk about awards quickly, very briefly, okay. The awards under the Sex Discrimination Ordinance at the moment, the maximum award is 3 months' salary. Let me see if I can find it. In Jersey, the maximum award under the Jersey discrimination law is £10,000 for either actual loss or hurt or distress, or the combination of the two. But
what were the legal costs for actually getting the £10,000?
yes, yeah. Okay. The thing about this, the Guernsey Sex Discrimination Ordinance is that this is 3 months' pay for an act of discrimination. You could have two people who have experienced exactly the same discrimination. One would get £40,000 and the other would get £1,000 because they earn a different amount of money. And the UK Equality Act, in theory, the awards are unlimited. So what should Guernsey do?
Obviously, you can't go with the pay thing because if you're moving away from just employment.
Exactly. No, that's right. Sorry? Simon said that if our law is... Simon says, I'm sorry, I just couldn't... yeah. If our law is going to protect in access of goods and services and education as well as employment, then obviously the salary formula thing just doesn't work. And again, I'm sorry, I should just say that is something that the GDA tried to explain to the first legislation group, because that wasn't understood. And the first legislation group said, we're only here to deal with disability. Anyway, thankfully, this new crew are much better and have listened. And I think it's highly likely that the existing ordinance will be changed or repealed or something at some point, because we couldn't have vastly different awards and systems, really. So, but there is a balance, isn't there, here, between that there has to be some sort of dissuasive effect. I mean, I think £10,000 to some very large organisations, they would just see that as a fee to discriminate, wouldn't they? Or am I leading you here? So,
I think it has to be proportional.
Sorry. Okay, we're straying into two things. So legal costs and awards for distress and so on are slightly different. What we're hoping, we think that access to rights you shouldn't pay anything for, and under the existing system we have the Employment and Discrimination Tribunal. It doesn't cost anything to take a case, and you don't have to be take a lawyer if you don't want one and if you can't afford one.
Well, are they reviewing that, the costs of taking a case?
I'm not aware that you're talking about here. I know they did in the UK. They did in the UK, and they slapped fees, and the number of cases dropped dramatically, and then that was overruled by one of the higher courts saying no, it's wrong to charge people in tribunals.
Do you know how they do it in other European countries? Because if I was imagining there'd be lawyers' costs, I think lawyers would be licking their lips and pushing cases in areas they shouldn't go to unnecessarily. Do you know of any countries that do it? You know, it's like you said, it's not paid.
Oh yes, yeah, there are loads. You don't pay for access to justice in Canada. There's probably a load of European countries, but I don't know them all. You don't pay for anything to have if you in Australia at the first stage, which is where you could have your complaint heard by the Human Rights Commission, but you would pay if you were going to go to court.
And is this what you're suggesting goes into Guernsey's legislation?
I would like to see access to justice to have no cost to it.
Yeah, that's good.
Particularly for the most vulnerable people on the island. Yes, Andre?
There's a very, very important issue in relation to these three parts, and I do think it needs to be unlimited. And one, for the very simple reason is, if you're front page of the press that you've been discriminated against in employment, almost everybody's going to do a Pontius Pilate and find some way not to employ you.
You're blacklisted.
You know, and you kind of like Deputy Gullops just said, you could be blacklisted. But there's another thing that you haven't mentioned, and I'm hoping I'm not stealing any thunder here. The difference between a discrimination law and human rights law. I can sue you as an individual under disability discrimination, but I can't sue you as an individual under human rights.
Okay, the legislation that we're developing here is an expression of human rights law. The convention requires governments to extend the protection already given to citizens against the actions of governments. It asks governments now to extend that protection to in all other spheres. That's what the convention is all about. So, and actually in Canada, they don't have a discrimination law. They have a human rights law, and it's written in these terms. But you're correct that under the human rights law at the moment, you can only take a claim against the government. Yes.
Or a corporate entity.
Yes. Or a government entity. Yes.
No, I could sue a corporation. I can't sue.
No, you can't. Not under human rights law at the moment.
You can't sue a bank.
No.
Human rights law.
Can you not?
No.
Oh, I beg your pardon, and I'll accept it.
No, but that's what this legislation will do for you. It makes it. The domestic legislation will extend this to employers, goods and services, and education. Yeah. So it extends the human rights bit, but the human rights bit is a non-discrimination, isn't it? Really? Yeah. Questions? Thoughts? I mean, it's been a long evening. I don't think I'm going to go any further than that. I hope it was useful to try and see what all the stages are that we've got to go through, the work that's got to be done. And although I want to see it tomorrow, realistically, it's not going to be tomorrow. But also, just as a general note, the GDA needs its members to support it in this work. You can see that if you hadn't had the GDA, you could now have a very nasty bit of legislation. So I mean, the GDA has accomplished an awful lot in its 10 years. But if we had only accomplished this one thing, which is actually preventing a bad law, I think it's worth us existing. And we need support. Thank you. Thank you very much. I'm completely dried up. Finish.